not used that often. I think whether or not we appeal will probably depend upon the sentence and further thought from Mr. Lewis.
Earlier tonight, there seemed to be some confusion in some ways, or at least questions by the jurors. What did you make of all that?
Well, I think I made of all that the fact that they were confused between the two charges, because first of all, they do really kind of overlap, and I think they had trouble interpreting the difference between the two. Just seemed pretty logical to me that it's an ambiguous statute. The charge that the jury, as you heard, was, I think, very, very ambiguous.
Do you feel that they were able to make a decision ultimately, though, as they were not guilty under common law and guilty under statutory, they were able to make the differentiation? Would you care to speak to that?
There is no differentiation between the two. That which would convict someone of statutory would also convict someone of the common law. And that was the real problem with both those statutes, and that's been our position since day one in this case, that you cannot have both of them.
So we can expect that as part of your appeal?
Yes, that was definitely part of the appeal. That, and primarily the very ambiguous wording of the statute itself.
Even once you've gone over it and spent the time to add the word official, or, and, et cetera, still objecting? It helped ambiguity. It didn't cure the ambiguity.
How's Mr. Lewis doing at this point?
He's disappointed. He was. We felt like that we established what we needed to establish in this case to get a not guilty on both of them, and the jury disagreed with us on the lesser count.
What do you make of the time that it took to come up with this verdict, too?
Well, it's obviously they had trouble understanding the law as read to them and trying to understand the concepts. They had a written copy of the jury charge in their possession, and it still took them a long time to figure this out.
Anything else, guys?
As far as the requesting that he be able to spend one more night in his home, is that more of a personal matter, or you mentioned regarding his safety?
Well, this is a one-year sentence. He has no record. It is something that really he did not gain anything monetary-wise from his actions, and therefore we think that the best thing is to give him a probationary sentence tomorrow. There's nothing going to be he loses his job as sheriff because of this conviction, and he would probably be willing to go to jail for a year and keep his job as sheriff if he could, but that's not going to happen.
Mm-hmm. In terms of the sentencing, it is a maximum of?
Maximum 1 year and $1,000 fine, yes.
What's the minimum, or do you even know?
0. Probation. Theoretically, the judge could fine him $100 and send him home, but that's not likely to happen.
What do you think could happen?
Well, it could happen, a short period of incarceration and probation. I don't know. Rick Quinn, who was sentenced for statutory violation down in the lower part of the state, as part of the state grand jury proceeding, recently received basically a probationary sentence and community service. And I think some of his allegations were more serious than this.
You mentioned, because of his history as a law enforcement officer, that there are safety concerns with him spending a night in jail. How does that factor into his sentencing going forward?
I think it should factor into the sentencing going forward. Clearly there is. Is there a need to put him in jail for this conviction as opposed to the 10-year common law? And there certainly is no need to put him in jail for punishment. There is no need to put him in jail to deter other actions by other public officials. So there's really not a benefit to society except to spend a little extra money for putting him in prison.
And could you speak more specifically to those safety concerns?
Well, the fact that he is a sheriff and you are putting him in a prison with people who do not necessarily like sheriffs. So that's kind of simple.
Sure.